So we're gonna try to get in as much as we can. We need to make sure that we discuss all of the final reports today. So I will convene the meeting at 1:05 p.m. And take roll. We have Jeff, we have Laurel, we have me, we have Carol, we have Thad, we have Judge Hall, we have Deirdre, we have Mihoko, we have Lauren here, and that should constitute quorum. Does anybody have anybody 18 or older present nearby to disclose?
I have my daughter in the room, but she's under 18.
Okay, great, thank you. Anyone else?
Oh, Dr. Andaya just joined us. That's great.
Great. Okay. Okay, so if no one has any disclosures, Brennan, we don't have any public testimony, do we? No.
No hands raised.
Great. So let's move
never
on.
mind. Now we have one hand raised.
Oh. Does someone have something to say about the roll call or the disclosures?
No, they put their hand down.
Okay. All right, great. So we're going to move on to agenda item B. I do want to thank the task force for making time for this rescheduled meeting today. Today we will be having the PIGs present their final reports on their findings and recommendations for updating Hawaii's parentage laws. In the interest of time, we will organize discussion as follows. We will hear from the applicable PIGs regarding their final report, and then we will hear from any members of the public who wish to testify. As a reminder, each person will be limited to 3 minutes. When public testimony is complete, then the task force as a whole will have an opportunity to discuss the findings and recommendations and ask any questions of the PIG or any member of the public who has testified. This will be a good time for us to get clarification on any of the findings and recommendations before we deliberate and submit the reports to a vote next Friday.
Sienna, 2 more task force members I think have joined since you did roll call. So can we just make sure that that's noted, because it's going to affect the quorum later?
We do have Dr. Frederelli and
Dr. Andaya. I don't know if you caught her when you did your roll call.
I did, thank you.
Okay, terrific. Thank you.
Okay, with that, let's move to the assisted reproduction PIG.
I think Carol and Dr. Frederelli are about to throw me under the bus. Are you going to do that, Carol, or should I have you do the presentation of our PIG?
Yeah. I'm 100% going to throw you under the bus.
Okay, thank you. Okay, I'm just gonna go with that. I'm just gonna lean into it. Okay, so our PIG did our report. There's not a lot that's changed from our concept document, which I think is fortunate. So the additional policy recommendations are in our final report. And what we wound up deciding, and this was a really brilliant idea that Sean came up with, was for the mental health consultation, which was the one part where our PIG did not have consensus. We decided to have compromise language where we put proposed language in section XX to ensure that the parties' expectations about any mental health consultations are addressed in the surrogacy agreement, but not mandating it by law. So that would mean that it highlights the existence of this question, and the surrogacy agreement should answer that question, but it's not requiring that the intended parents undergo a mental health consultation. And so we had talked about the pros and cons of that before. The pros and cons are the same as they were before, but that our PIG did land someplace different than the last time we talked about this. So that's probably the new thing. And then the other new thing was the health insurance provision, which we had struggled with. This is again for surrogacy, and section XX6, and it requires a disclosure that would require the attorneys preparing it to like summarize health insurance, which we did not want to make anybody do, because good luck figuring out what it says. And it just seemed like an invitation for, like a burden that really could not realistically be taken on. And so Carol did some terrific research, and we found a enactment that we all particularly liked from Connecticut, which has enacted the 2017 UPA. And they didn't have the UPA's provision on insurance, but instead had their own provision that we really liked. We thought it was really well written and also had some really great concepts articulated in it. So it basically has basically the disclosures that you're supposed to state if it's covered, and this is in the draft bill, and also to state that insurance companies can't get out of it because the intended parents have to cover, right? So like if a surrogate then has some medical problem while she's pregnant, whatever her insurer still has to cover her, even if the intended parents also have some responsibility under the surrogacy agreement, right? So we laid all of that out. That's a change from the last time we spoke to the task force, is because we had been struggling with that provision, but hadn't really landed on how to address it. And I was particularly pleased with that. When we looked at some of Connecticut's law, I was like, oh, this is a good law. Like it's just, it was well written and really kind of articulated what we really wanted on that. So all we did compared to the Connecticut provision was adjust it so that it lined up with the rest of the bill, like the definition of a section versus a subsection, so that it matches with the HRS, stuff like that substantively. And then the only other thing was, I think they had made something mandatory. Was it a life insurance policy? And we made it optional and to line up with current practice. And then the last thing, then the other stuff that is noted as substantive amendments that were done in our draft bill is confidentiality. That's the same as we had said in our concept document. So we decided that it should be up to the parties to a surrogacy agreement, whether and to what extent they're agreeing for it to be confidential, because we think it's really up to them. But we did think it was prudent to lay out that the law says the surrogacy agreement should address confidentiality, not require that it be confidential, because we thought, I don't know why we'd have to impose that. It's up to them. We had mentioned at the last time when we were discussing the concept document that we wanted to be sure that the assisted reproduction and surrogacy portions of the proposed bill were drafted in a way that would accommodate reciprocal IVF for a couple of two women. And after thinking about it a lot, we decided that we didn't need to change it, that it already fit within the existing language. So that's helpful, but we did study that because we were concerned that that was a particular arrangement that we know is happening, and we didn't want it somehow to get lost in the way that the bill was written. But after some real study on that, we arrived at, we think that it's okay as is, that it's already within it. We don't have to highlight it as a specific thing. And then there was one edit to section SS about withdrawal of consent for assisted reproduction. And there was one part which didn't quite seem to read consistently with the rest of the bill, where, if a couple's gonna consent to assisted reproduction, you can withdraw your consent, but not in the in-between after the transfer and whether you find out the pregnancy has happened, right? And that's the same as everybody else, right? Like you participate in the act to create the child, you don't get to change your mind after that, right? And so there was one provision, the SS, that didn't seem quite to read correctly about that, although the other provisions were clearly said that. So we did a minor adjustment to make those line up and to make it, I think, consistent with the obligations that come with parents, right? It would parallel the responsibilities attaching to heterosexual parents who reproduce biologically, right? So you can't change your mind after the deed is done. So any case, so that's where we're at with that. Attached to our report, and that's like the first couple of times, was our concept document as originally submitted in May, and then the draft portion of the bill, which was redlined by our PIG. And we started with our portions of the bill that Judge Hall had given us, right? So you'll see that a lot of times there's notes in the bill, and we put that in there in order to reference these exact changes, right? And then a lot of the other stuff is like minor edits, right? Meaning, to make it a little bit clearer, but not intended to change the substance of the sections, right? So the stuff that was substantive movement we've outlined here, there are a fair amount of smaller edits. Like we felt that the use of the word individual twice in the same provision to refer to two different people was very confusing, and we understood and agree with the intent of using gender neutral language, which the UPA does not. But we felt like there was some clarification. So sometimes we would say an individual and another individual to make it a little more intuitive that you're talking about two different people. So you'll see that kind of edit throughout. It's not intended for substance so much as just clarity. So anyway, I know we've talked about most of this stuff, except for the insurance provision. We've talked about all of this before. So I don't know, that's it for me. Carol, Dr. Fratarelli, is there anything that I missed?
That sounds pretty comprehensive to me.
We lost Dr. Fratarelli. Oh no, there he is. Okay.
Yeah, no, sounds good.
Okay, well, I think that's it for us then. Happy to answer any questions.
Brandon, is there anybody from the public that'd like to testify?
No raised hands.
Okay, open to discussion. Does anybody have any questions for the PIG on their final report? Anything to clarify?
Oh, I forgot to say we added some definitions. The most consequential one is the definition of the word embryo. Which we wrote with Dr. Fratarelli's help so that it is both legally operative and medically correct.
And I
And
just
you did-
wanna, oh, go ahead, Carol.
Well, I was just gonna say, Deirdre, you did not explain the Taylor rule.
The Taylor rule, right, since Sean is not here, which is unfortunate, is that Sean was encouraging us not to make changes if we didn't need to, meaning if we wanted to agree with what the UPA was doing, just leave it. And so then Carol nicknamed it the Taylor rule, with caps and that kind of thing. And then she started saying that it was influencing her practice. Anyway, it's been kind of a joke in our PIG.
It
So
works well
I
in
am
life in
relaying
general.
the Taylor rule, which the group of us came to conclude was a sound method of approaching this giant legislative project. Like,
If it ain't broke, don't fix
if
it.
it ain't broke, don't fix it. And if we got the UPA provisions, then the only real changes were to make it gender neutral and then, to make it so that the definition of a section and subsection is correct for Hawaii law. So we did go in circles about some edits where we wound up back where we started under the Taylor rule, like don't change it. So
Kind of
anyway,
the
you can
concept
tell
of-
Sean that we have relayed this.
Yes. Kind of
Since
the concept
Carol
was
said she was gonna tell the task force.
the concept was avoid unnecessary wordsmithing, which some of us are guilty of trying to do.
But I just want to say thank you to the PIG because your recommended changes are extremely thoughtful and very well thought out, and I think they can make the proposed bill much stronger.
Oh, I'm glad to hear that. Thank you, Judge
Thank
Hall.
you.
That's a very nice compliment. Yeah. I really enjoyed the PIG and it was a real blessing to get so much expertise in there. Because I can tell you how to write this statute, but I don't know what's going on like in the field. Like, how does this actually work? So, yeah.
Okay, so any other comments before we move on to our next report? Okay, so let's.
Woo! Okay, thank you. Sorry, that was, unofficial.
All right.
Thank you, everyone.
Earth Heritage PIG, Laurel, I assume.
Well, we never designated anybody, but somehow, and I won't call it being thrown under the bus, but we pretty much landed with our recommendation the same as last time. And I wanted to thank Jeff and Carol in particular, because they both had some really good changes, some of which were accepted by me and so much weren't because it was like 9 or 10 o'clock at night before we had to turn this in. But everybody participated, and Dr. Andaya did participate in our last meeting, and she had some thoughtful comments, I think, as well. So I do want to thank everybody for being there and really being there. So while we didn't agree on our recommendation, we're still split on our recommendation. I'm presuming that we will take a vote next week on that. I think in order to not go on too long, I think we have some testimony from people, and I know that I think Jeff had a statement he wanted to make, so I'd like to give the time over actually to that. So thank you.
Thanks, Laurel. For clarification, I wrote another personal statement, so it's not actually summarizing. It's just something that I wanted to say. It's not my intent to relitigate the birth heritage discussion. We've done that enough, but I made some comments at our last meeting that I regret, and I appreciate if you would allow me to follow up. I felt that my moment at that meeting was a low point for me, but sometimes, as I tell my children, one's poor judgment can lead to personal growth and or learning. And I sincerely hope it did for me. To be specific, I had disparaged the professor's theory without fully understanding it. So I reached out to him, and on an objective basis, And he agreed to meet with me on Zoom. We met on July 15th, and according to my recording, our conversation lasted 18 minutes. This is Dr. Glenn Cohen, and he's a bioethics philosopher. Many people find his theories incredibly difficult, including myself. But the gist of the one theory under discussion is that, and I'm going to try to summarize it, when you consider replacing a theoretical population that never existed by using a different set of parameters leading to the potential existence of a different theoretical population that may or may not ever exist, it is not philosophically logical to consider harm to that first potential theoretical population, because the new theoretical population would be created from a different set of parameters. In this case, a possibly different set of donors. Yes, I find it very theoretical. And although his theory was written directly concerning the concept of anonymous versus identifiable donors, he never actually takes a position on it. He's focused on reasoning and logic behind the reasons for taking one position over the other. I asked him if I could make an analogy, and I asked if closing a donor bank would have the same effect on such a non-existent theoretical population. He said, yes, it would. And I then asked him if he himself were an intended parent choosing an egg donor, if it would matter whether he chose anonymous or identifiable donor. And he said identifiable. And I'm going to quote him directly. He says it better than I could paraphrase it. Why would I not have the option value of later getting in contact with them? The real question is whether I should get to make that decision for my child, or the child should be able to make the decision on their own later on. I definitely would choose a donor who is not anonymous so we could have access to this information if we want it, but under no obligation if we don't. It's like the best of both worlds. I asked him if I could share that with the task force, and he said yes, that I could. I've since signed up to take an online Harvard course of his called Bioethics, the Law, Medicine, and Ethics of Reproductive Technologies and Genetics. And it's free, and I find it fascinating. I'm not done with the course. Dr. Cohen has a young lady named Katrina Clark present her story as an anonymous donor conceived child. And I just wanted to finish my statement today with some statements of hers in her words. The children born of these transactions are people too. It's hypocritical of parents and medical professionals to assume that biological roots won't matter to the products of the cryobank service when the longing for a biological relationship is what brings customers to the bank in the first place. Thank you for your time.
Thanks, Jeff, for sharing. Does anybody else from the PIG want to make comments on the final report before I check for public testimony? Okay, Brandon, are there any hands raised?
Yes, one hand.
Okay, you can go ahead and let them in.
Oh, two hands now.
Okay, just the first one.
Yep.
Hi, Tyler. Just a reminder, you have 3 minutes. And I'll start when you get started.
Hey, can you hear me?
Yep.
Okay, let's try my best to stick to 3 minutes. I believe I will. Ultimately, I'm going to ask this body to apply the Taylor rule that was mentioned by the other pigs as helping them make a decision. And I'll explain what I mean at the end. As you know, my name's Tyler Sniff. I'm with the U.S. Donor Conceived Council, which is one of the only nonprofits advocating for donor conceived people and their families. I'm going to briefly summarize the importance of adopting the current version of the Uniform Parentage Act, which includes an update to Article 9 on gamete donor identity release, which will be referred to as 2024 Article 9. First and foremost, numerous respected organizations have submitted testimony in support of 2024 Article 9, including the Uniform Law Commission, the National Center for Lesbian Rights, Collage, which is a nonprofit advocating for children with LGBTQ parents, the Sperm Bank of California, leading researchers and law professors, and mental health professionals with decades of industry experience. My first point is that 2024 Article 9 is needed given current realities and technologies. At-home DNA testing and facial recognition technology has made it impossible and deceptive for companies to promise anonymity to gamete donors. And this has been recognized by leading researchers, including Dr. Joanna Scheib, who submitted testimony. 2024 Article 9 addresses this by requiring all future gamete donors to consent to identity release at 18 as a baseline. Other states, Colorado, have adopted this as law. Point 2, 2024 Article 9 protects the health and welfare of donor-conceived individuals. Several peer-reviewed studies cited in our comments found that many donor-conceived people have a strong desire to know the donor's identity. Having access to identifying information as provided by 2024 Article 9 will protect the health and welfare of donor-conceived people by giving them identifying information which is important for identity formation and accessing important health information. Number 3, our 2024 Article 9 will not destroy the donor gamete market. As shown in our submissions, the supply of donor gametes has increased over time, and data from all U.S. sperm banks shows that the cost difference between identity release and anonymous donor sperm is only about $147 per vial, whereas the average anonymous vial costs more than $1,000. It is also likely that this modest cost difference is due to factors other than identity release, such as the increased overhead that's come with recruiting newer donors. Critically, most major gamete banks in the U.S., which account for a very large percentage of all donor gametes available to Hawaiians, are requiring all new donors to consent to identity
I'm
release.
going to ask you to wrap it up, please.
Okay. I have 2 short paragraphs. As stated in our comment letters, there are multiple gamete banks and fertility clinics licensed in Hawaii that would be subject to this article, including the IVF clinics in the state, all of which, according to CDC, have an egg donor program. For these reasons and those in our letters, the U.S. Donor Conceived Council joins many respected organizations and professionals in urging the task force to follow the Taylor rule. If it ain't broke, don't fix it. And that therefore adopt 2024 Article 9, which is the official position of the Uniform Law Commission. If the task force does not adopt 2024 Article 9, we urge the task force not to adopt any version of Article 9 and let the legislature decide the issue. Thank you.
Thank you. Brendan, can you bring in our second testifier?
Carol, did you want to ask a question or?
Yeah, Carol, I'll get your question after we do both.
Yeah, that was my expectation. Thank you.
Thank you. Hi, Jamie. I'll start your time when you go ahead.
Hi guys. Thank you guys so much for having me. I'm just hoping to clarify a little bit some of the testimony that you have received most recently. The 2017 UPA was updated to amend Article 9, and there's a couple of different names that were being used for it. And so I want to make sure we're clear, because there was some discussion about older versions of Article 9, both the testimony submitted by Joanna Scheib as well as the Uniform Law Commission both recommend using the updated Article 9. The Uniform Law Commission submitted testimony. The testimony highlights a number of important components, including some important reasons why Hawaii should adopt the current version of the Uniform Parentage Act, including the 2023 amendments to the Act. Most notably, it talks about how the focus of the Uniform Parentage Act from its first iteration in 1973 to the modern act currently recommended for adoption in the states has been to protect children, recognizing the importance of children having access to information about their medical and genetic history is consistent with the values of the Uniform Parentage Act 2017. I want to encourage the task force to please adopt the updated Article 9. It's really important to donor-conceived people, donors, and parents alike. thank you so much for your time.
Thank you, Jamie. Brennan, do we have anybody else?
One more.
Okay. Hi, Melanie. You can turn your video on and mic on, and I'll start your time when you get started.
I think I'm up. Hi, to the members of the task force. My name is Melanie Mickelson, and I'm a licensed clinical social worker with 24 years of experience in the reproductive mental health field. I've worked extensively embedded with fertility clinics, egg banks, and third-party reproduction programs. I'm also a former fertility patient and a mom. I currently serve as the chair of the American Society of Reproductive Medicine, ASRM's Mental Health Executive Committee, but I am speaking today representing myself. Over the years, I have interacted with numerous egg, sperm, and embryo donors, as well as the intended parents of these donated gametes. There's been a significant shift in the industry regarding the loss of anonymity, especially with the rise in direct-to-consumer DNA testing that we all know about. Most of the sperm and egg banks I work with now only accept donors who are open to the release of their identifying information to donor-conceived offspring once they reach age 18 years of age or older. I regularly counsel donors on informed consent to help them manage their expectations regarding this decision as well. It's crucial to understand that while privacy can still be maintained, anonymity is no longer feasible. In my experience, the adoption of laws and policies related to donor identity release has not resulted in decrease in donor applications, nor has it led to an increase in cost. For instance, 75 to 80% of egg donors at a national frozen egg bank have agreed to identity release, indicating that donors are receptive to the shift. Similarly, in a pilot program at a sperm bank, nearly half of the donors have agreed to earlier disclosure of their identifying information upon confirmation of a pregnancy, of a live birth. In other words, before the child turns age 18. This also demonstrates that such policies do not deter prospective donors from considering this option. It's important to note that these shifts are designed to enhance access to care for intended parents while ensuring that donors have a clear understanding of the lifelong implications of their decision. Donor-conceived individuals also benefit from having access to updated health history and the opportunity to explore their genetic heritage. For these reasons, I believe that the time has come for us to embrace law and policy changes such as 2024 Article 9 of the Uniform Parentage Act, which prioritizes the well-being of intended parents, their children, and donors. I urge the task force to include 2024 Article 9 in its UPA bill. I am ready to address any questions that you might have, and thank you for this valuable work you're doing, and thank you for this opportunity.
Thank you, Melanie. Brennan, you can put her back in the the waiting room for now. And Carol, your question?
Actually, it's more of a response than a question. Is that okay?
Absolutely. This is our
Okay.
time to discuss.
Thank you. So I wanted to make a few points. One, I think it's a mistake to talk about donor-conceived people and their parents as a monolith. There is a huge variety of perspectives within the donor-conceived community. I think it is true we tend to hear mostly from those who are dissatisfied with their anonymous donor-conceived status. But as I pointed out in prior meetings, if we needed to line up 40 people to come here and testify about the fact that they're happy with their lives and they don't feel it's having a significant negative impact on them, we could. I don't think it's necessary. But there's more than one perspective in the donor-conceived community from both donor-conceived children and their applicants. I am a donor-conceived, anonymous donor-conceived parent. I have 2 anonymous donor-conceived children who live with me. So I regret that I am I'm being consistently told that no other perspective exists, because obviously that's not true. The second thing I'd like to say is I 100% agree we need to apply the Taylor rule here. But the Taylor rule is one of broad applicability. If it ain't broke, don't fix it. And what we're being pushed to do here, largely because many of these advocates need some state, any state, to adopt the UPA 2017-2024 update to Article 9, is to adopt a law that is going to have essentially no impact in the state of Hawaii. We do not have, notwithstanding the list provided in the most recent submission from USDCC, when you look at the list of banks that they included, 3 of those are trade names. John, I'll let you speak on this after this if you'd like to. 3 of those are trade names registered by our own task force member, John Fratarelli, for marketing purposes. They are not active donor banks. The 4th they list, Cooper Surgical, is a medical device company that provides the devices that are used in fertility treatment. It is not a donor bank. It does not bank anonymous donor gametes here in the state of Hawaii. So it's very misleading to suggest that these are all sources of anonymous donor gametes being banked in the state of Hawaii, because they are not. In fact, even the reference to them being licensed in the state of Hawaii, I'm not sure what they're referring to. It looks like they might be referring to DCCA registration, which is not the same as being a licensed gamete bank. But anyway, John, you know this better than I do, but to my knowledge, we do not have any gamete banks in the state of Hawaii. So the broader application of the Taylor rule is we should not be pushed into adopting a law that we have time to wait and see how it affects other states where there are actually gamete banks licensed. We have time to see how it affects. Another major concern I have, I'm not a fan of legislative process. I love you all. I freely admit I'm not a fan of this process, because I don't enjoy advocacy that doesn't acknowledge both sides of an issue. I do not know why in the submission from USDCC yesterday, they state in the 2nd paragraph of item 1 that California Cryobank is, quote, one of the largest sperm banks in the world. And yet in their table, cost of identity release versus anonymous donor sperm, which they refer to as including all major banks, they do not include California Cryobank. I would like to assume that's an honest oversight, but I note that they come up with an average difference in cost of $147 a vial. But as of 1:30 this morning on the California Cryobank website, the difference in cost between an anonymous donor vial and a donor disclosure vial is $1,000 per vial. It is $1,195 for anonymous donor. It is $2,195 for a known donor. That is on the website. It is easily available. I don't know why it was omitted from this table, but obviously it does not assist their narrative that we're talking an average difference of $147 a vial. The bottom line for me, and I've stated it multiple times, so I'm not gonna belabor it here, is this is a very significant extension of the law that we're being asked to do. We're being asked to make a law that intrudes into the private procreative parental decision-making of Hawaii parents before conception in a way that we do not do in any other circumstance. Physical disability, mental disability, unstable home environment, take your choice. We don't do it in any other circumstance. But we are being told this is so important now, notwithstanding the lack of licensed active licensed gamete banks here using anonymous donors, that we should pass a law. We should be the first state in the nation to pass this version of the UPA. And my response is, I'm not necessarily adverse to it, but there's no rush. We have plenty of time. Let the states that actually have these things happening and are actually banking anonymous donor sperm in their states, let them do it first. Let's see how it affects availability. Let's see how it affects the LGBTQ plus community. Let's see how it affects single people. Let's see how it affects infertile people. And then if it makes sense, absolutely, let's adopt it here. But we're being told it almost doesn't matter that much because of the ready availability of DNA testing. It almost doesn't matter that much because we're being told all the sperm banks are changing their policies anyway. We're being told flat out anonymity isn't even possible anymore. And yet somehow it's critical that Hawaii be the first state in the country, not the first to adopt any kind of mandatory disclosure law, because Colorado has done that, but that we be the first state in the country to adopt this version of the UPA. And I think it's because they need somebody to break the ice and give them momentum. And I don't think that is our role as the state of Hawaii. I think we do what is best for our people based on the actual state of our law right now. And the state of our law is this is not going to affect most anonymous donor use in the state of Hawaii. We have time. to see how this plays out in places where it will actually make a difference. Thank you.
Deidre, you had your hand up, but you took it down, right? Before I go to John.
Oh, thank you. That was nice. I want to hear from Dr. Frederelli more than I want to talk.
Okay.
So please go next to him.
Hello, hi. Yeah, I just wanted to kind of echo some of Carol's words. Yeah, I think what I've heard a lot about is the right to choose, and I think it's important for the donor to be able to choose as well. And right now, that's what we're allowing the donors to do, and a lot of donors are choosing to disclose their identity. All donors are choosing to disclose their medical conditions, their psychiatric history, their genetic history, their family history. You know, again, the donor conceived child and the intended parent get so much medical information and family history from that donor, much more than I think a lot of us know about our own families. So the donors are choosing to do that, and a lot of them, as time goes on, are also choosing to do ID disclosure. There are no egg banks. Well, none of the major egg banks, maybe some boutique egg banks, but none of the major egg banks are at this point mandating ID disclosure. They are all offering it. They are all suggesting it and recommending it, but none of them are mandating it. As far as sperm donations, Mr. Smith's notes or letters said that several of the major sperm banks were mandating ID disclosure. That's not true. Seattle Sperm Bank is. None of the others are. Okay, now they are trying to get there. They would like to get there, and what they say is that they are offering it, and that the donors have to sign an authorization. And basically what they're signing is they're signing, yes, I'll do it, or no, I won't. That's what they're signing. They're not signing, they're signing an ID disclosure form, but the ID disclosure form isn't saying that they will disclose. It's telling them they have the choice. And yes, there are a large percentage of them that are choosing to do that. And then a couple other points just to back up what Carol said. You know, the cost of the sperm is $1,000 more, which double the cost for ID disclosure. And the cost for eggs is a little over $1,000 more typically. And then none of the licensed banks here that are listed are banks in Hawaii that do this. I mean, I think that California Cryobank is listed on here, but they're a national egg bank. They're not Hawaii based. I have a sperm bank, I have an egg bank, and I have an embryo bank. But that's because of the autologous egg, sperm, and embryos that I freeze for my patients, and for marketing purposes, I wanted to tie those up. You know, and because I am a bank for my patients autologously as they freeze their gametes and embryos. But none of the others, and that's Cooper Surgical. Again, it's a vendor that we use and other IVF clinics use around the country and world. I don't think that they're licensed in every country. I may be wrong, or in every state. I might be wrong, but I'm pretty sure they're not. I think that it just we need to realize that everyone has the right to choose, and at this point, also the donors do, and the donors are doing the right thing now. They're more and more of them are starting to choose ID disclosure, and I think it's coming around. But I think it certainly needs to be left where everyone has a choice.
Carol, addition?
Oh,
You're on mute.
Okay, now Deidre put her hand up.
You're on mute.
There we go. Sorry, sometimes it doesn't cooperate. I forgot to mention one. I wanted to emphasize when I say $1,000 price difference, that's per vial. My physicians, at least when I did my donor insemination, recommended I buy 8 vials at a time. Some people it takes a lot more than that. Some people are lucky it takes less. But so we're not talking a $1,000 difference per episode of trying to procreate, essentially trying to create a child. It's usually an $8,000 to $10,000 price difference, or more if they're unsuccessful. The other thing I just wanted to mention was I remembered Mr. Sniff said at the end, if you don't adopt our version of Article 9, don't adopt any version of Article 9. That is a politically motivated leverage creating device, right? Why would we not, when we have absolute anonymity on the value of mandating disclosure of non-identifying donor information, important medical, health, and heritage information? Why would we not include that in the statute now, knowing that our PIG was unanimous on it? I suspect our task force may well be unanimous on it. The only reason to not pass that version now is if somebody believes it'll give them leverage later on to say we haven't touched Article 9. But we have a version of Article 9 that allows us to wait on the disclosure issue and see how it affects other states, and allows us to immediately move forward on the availability of medical and heritage information. So I forgot to mention, I do not agree that we should leave a gaping hole in the bill in hopes that, somebody can have another shot at filling it with their preferred version of Article 9 when we get to the legislature. I think that's purely recommended for leverage, as opposed to doing what we think is the best thing.
Carol, Deirdre?
Thank you. So I wanted to just say, as I've been listening to all of this, and this is something I said last time, I think that every position that I've heard about this, everyone is right all at the same time. I hear nothing but sincerity and good faith from everyone. But I think for me, the deciding factor is that this issue lies at the intersection between what's a good idea and what the government should tell you to do. That's why this is so sensitive. And so I'm heartened to hear that the direction of the community, in terms of the direction of the expectation of donors, is headed in the direction of identifying, because I think that that's a good idea. But just because something is a good idea doesn't mean the government should decide it for you. And that's the difference, right? That's, for me, that is the difference. And then in terms of, the legislature, the work of this task force is very important, and I felt very privileged to get the chance to do it. But the policy decisions will be made by the elected members of our state legislature. All we are doing is giving them a bill to start with, right? And so we don't have we can speak as individuals, whatever, but we're not making those decisions. We're just giving them a starting place, right? And that is the intention of the task force, is to have them start with a bill that's already been vetted by people who are stakeholders in these various communities that are addressed by the entire bill, right? And if you look at the mandate from Act 156 that set us up, I think we do need to provide the majority task force vote on the UPA, which includes yes or no, including addressing this particular issue under the 2017 version or the more recent one. Right. So I don't think we can answer it with a blank, because that wouldn't be doing the job that this task force has been asked to do. So it's going to have to come to a majority vote, in my opinion. Right. But in terms of we're not making decisions for the legislature. Nobody should think that. We're going to be giving them, I hope, and I have every faith that the work of this task force is going to pay off, because they're going to have the benefit of all of the effort that all of us have put into the entire bill. And they won't be starting with a blank piece of paper, which would be extremely difficult, right? So anyway, I just wanted to mention that. And I wanted to just reiterate that it is possible to look at this debate and see, as I do, sincerity and good faith on all sides. But to me, the deciding factor is the difference between something I would love to see happen because it's a good idea, but whether the government should tell you that you must do it this way. That's a different question entirely. So that's where I've landed on it. And I want to thank everybody for their honesty and their heartfelt discussion of this, because I know it's hard for everybody. So thank you.
Does anybody else, thanks, Deidre, does anybody else have questions or comments or things they'd like to clarify from the final report of the Birth Heritage Task Force?
Yeah, okay. Sorry if I can. I just want to check with Dr. Andaya and Lauren if you had any parting thoughts that weren't maybe reflected in the report, because we did the best we could to balance it, but it was the best we could do. So.
No, I totally appreciate that. And it's, Deidre, you worded it so beautifully. You're so eloquent with trying to see both sides. And as you're talking, you introduce another side to it where it's like, oh yeah, well, is it our job, or is the government's job to make people do certain things? And that's that's another data point in my brain that now, thank you for introducing that to me, I'm faced with. And it's been challenging because of this topic, and I can see the sides, all sides, and the pros and cons of each side. So yeah, it's difficult, and I think I appreciate everyone voicing their opinions and their experiences and areas of expertise. So clarifying certain things as well. I don't have a hard stance on either side. I keep bouncing back and forth. So at the end, I think it will just, as much information as y'all can share with me, and I'm very new to this process, so I appreciate all the input, and I'm trying my best to kind of really look at it from the global point of my background, which is mental health, and how this is going to affect families and children, and in the future, as you know, hypothetical situations come into fruition, and what's going to look like in the end.
Thank you, Dr. Ndaya. I don't know if Lauren's available.
Hi, thanks for checking in. I want to thank Deirdre for her very articulate analysis that really resonates with me and expresses with much more clarity the sort of ham-fisted comments I said at the last PIG meeting, which is the role of government and letting the legislative process unfold. And I think it is absolutely critical that as much information as possible be given to the legislature for those deliberative decisions. So my position hasn't changed from the soft no from the last PIG meeting, but I appreciate the opportunity to reiterate that. And again, thank you, Deirdre, and for really making it clear about our role on this concurrent resolution. So thank you.
Thank you, Dr. Ndaya and Lauren. That was very kind.
So Sienna, I just had one more.
Yeah, go ahead.
Okay. So I just want to switch from being the reporter to now being the member. And I think you all probably know I got involved in this because I was really concerned about what I was seeing happening to birth certificates, but I've been educated and I understand now why we're moving in this direction, as much as it gives me some discomfort. I think, and we haven't gotten there yet, but I think I do understand better why the Legal Parentage Group has had to do some of the deliberations they've had to do. But it presents me with a dilemma, because to me, once we start changing birth certificates to something other than facts of birth and heritage, which is what we're going to be doing or recommending anyway, then the only remedy for that is Article 9 in the 2024 version, because that gives the donor-conceived child the opportunity, when their parents may in fact not have disclosed to them. Unfortunately, we know that happens. So that's my dilemma, honestly. I realize that a birth certificate in Hawaii, if this is adopted, will really no longer be a birth certificate, and it will reflect parentage. And this is the uniform parentage law. So, okay, I'm waving the white flag, but I'm really, really concerned that then if we don't state as a public policy that at some point a donor-conceived child can have access to information, then we've failed as a government, honestly. So I understand what Deirdre's saying, but as a public policy person for many years, sometimes you have to make a statement and drag people kicking and screaming with you to make them do the right thing. So I just hold a different position on that. But thank you for all the comments, and this has been a very good discussion, and I appreciate everyone's participation.
Can I add one quick thing to that? No worries. It's not debating you, actually. No, I was just going to say, actually, Laura, what you just said is interesting. Your point is well taken, that essentially what we're talking about would be more aptly labeled a legal parentage certificate than a birth certificate. Yeah. But I think that's been the case for decades. But I think, it's an interesting point that you make, which goes far beyond the birth heritage PIG. It also goes, of course, into our other PIG.
Yeah, sorry. So I got a little ahead of us there. So I
No,
apologize.
but it's a point well taken.
Thank you, Sienna.
Yeah, thank you. Anybody else? Okay,
There's one hand raised in the audience.
Oh, are they allowed to?
Did you want to let them speak again or no?
no, so we've
No.
already done public testimony on
Okay.
that. Yeah, on this topic. Thank you. Okay, so we're going to move on to B1C, which is a legal parentage pig. I'm going to be very brief because I came in at the kind of tail end of finalizing the legal parentage pigs report. And as I understand it, it hasn't changed very much from kind of what's already been presented over the course of this process. And so, you know, it pretty much summarizes the 5 points that the legal parentage pig had attempted to address in trying to update our laws so that we try to create as much equity as possible. And that's all I'm going to say. I'll hand it over to anybody else on the legal parentage pig if they'd like to say anything more on our final report, but I do think it speaks for itself.
I just want to state the final report really hasn't changed our position or the information we provided from the last couple meetings prior, where we had a long discussion about the changes we were making. So we really haven't had to make too many changes since then.
Brendan, is there anyone who would like to testify? And again, we'll be opening opening the floor to people who want to testify about this particular agenda item.
2 hands raised.
Okay, let the first one in. Hi, Tyler. I do want to clarify that you are only allowed to testify on agenda item B1C, which is the Legal Parentage Task Force.
Yes, I
Final.
understand. I want to say my integrity has never been questioned as an attorney, and I would like the chance to respond in the form of oral testimony at this meeting or next meeting to correct several inaccuracies and misstatements that were given in prior testimony. Thank you.
All right, Brandon, can you bring in our second testifier? Jamie, I'd like to reiterate that your testimony is limited to this agenda item, which is the legal parentage final report.
And I understand that. Okay, so what I want to testify to is about legal parentage and how that is the other half of the equation for queer families who are family building using assisted reproduction, and the ability to establish the parent-child relationship and the importance of that, and the importance for those families. This is a multifaceted issue, and I agree with Laurel that Article 9 is the solution, but I don't necessarily think that birth certificates come into question because I faced family separation because of the lack of legal parentage. And so I think that Article 9 as a whole is so important to this type of family building that it really needs to be considered as a whole. And so that's what I wish to testify to. Thank you guys so much.
Yeah, great. Thank you, Jamie. Okay, task force members, is there anything you'd like to discuss? Yeah, Deirdre?
Okay, this particular area with the presumed parents and the intended parents and the alleged genetic parents, I don't think I really understand it. So I have a very basic question, which hopefully Judge Hall will be able to answer for me, is that are each of these presumed groups of parents, presumed parents, intended parents, alleged genetic parents, going to be able to easier access and establish the legal relationship of parentage in a way that they can't do now if this proposal became law? Because I'm not understanding who these people are exactly. Without the hypotheticals, I'm lost.
True.
Yeah.
Yes, with the bill as it is the proposed bill as it is right now, it will make it for each group a little easier. Especially one of the provisions, which was a very minor change, which allows the court to do uncontested hearing proceedings. That will just allow them to do the paperwork and not actually have to come to court to do it with, and that doesn't only just benefit the alleged parents and all of that, it'll benefit heterosexual couples too, that for whatever reason was unable to do the process at the hospital, the voluntary establishment process at the hospital, or didn't want to go to the Department of Health. Or, for example, if the mother was still married, legally married, it allows them that process without having to go through the court system like they
Gotcha.
currently have to do.
Okay.
So it will definitely make it easier across the board for all groups.
Okay, so that's basically what I need, because I'm all about pragmatism with this. Like, are there people in need who the law could better protect if we did this? But I will admit that despite multiple attempts, I'm still puzzling over some of the terminology, and I bet that, you know, when the bill gets to the legislature, those people are going to be like, there's going to be a lot of questions about some of the stuff that's a little confusing about all these different parentage statuses. So that's just my warning. I'm certainly not going to vote against these things, but I've noticed how difficult I'm finding that. So thank you, Judge Hall. I just wanted to know, like, is it going to work? So thank you.
Hey, everybody. Yeah, thank Deirdre, thank you for raising that issue, because I too get so lost in trying to figure out what are these groups, who are they? And then I see in your report that there's hypothetical, right? Like you explain, like a person is a presumed parent if, and then all those scenarios come out. I just would suggest that maybe for the final report that we find a way to maybe put all the population, explain who the populations are in a way that people can look at it, whether it's a chart or bubble, flow chart or whatever it is, because I think that would really help to figure out, like, ultimately we are trying to make it easier for these populations, right? And I think if we're struggling with it after having dived deeper into it, I think just the legislature, it's going to be a challenge. So, but thank you for all your work on this. I appreciate it, and also support the work. That's
Shiana, can I jump in for just a second?
Yeah, sure.
Okay, I wanted to thank Mihoko for saying that, because I was impressed with, like, oh, you guys look at all these other laws and it was so thorough, but then I'm thinking I'm a lawyer reading this and I'm overwhelmed. So I do think we want to maybe think about a streamlined presentation on this issue for the final report, remembering what's going to happen is the final report and the bill all put together into one giant thing is going to go to the ledge by itself. And so it has to be understandable, even if nobody picks up the phone to talk to any of us, right? Like, you're going to leave it off by its lonesome. So the flow chart's a great idea, you know? If you're married to your spouse and the spouse is the biological, parent, then this is how then if it's not that and whatever, that would be super helpful. I also suspect the effort of putting that together would be illuminating, right? In terms of the number of potential varieties of circumstances. And I find that the hypotheticals about who are we actually talking about make it much easier to understand why the law needs to be expanded, because there's 1,000 different varieties of circumstances in which somebody would need the law to let them establish parentage in a way that's not burdensome, which is what we're after, right? So anyway, I thought that was a really good idea. So yeah, that's my only real thought, is that this is very dense. And so I'm thinking that you might want to do kind of a mini version for the report that's actually going to be delivered to the legislature. And of course, we have all of this. This is part of the public record of the task force itself. So none of this work will be lost. I can tell how thorough you guys are with all the footnotes and the lengthy conversation, but I think bullet levels is what's needed when it's going to be at the legislature by itself. So thank you.
Yeah, I want to just jump in. I think that, we've got a very thorough report, right? And the drafting pig can take that into consideration, and try to give effect to what was recommended here in a way that's digestible.
Well, I actually think that's two different things. There's going to be a report in text from the task force and then a proposed bill.
Yes.
So I think what's going to wind up happening is the report is going to wind up being largely a compendium of the final reports of the pigs, right? And the text is going to be a combined set of putting all the components of the bill together into one giant bill, right? But I think that the amount of density in this document sort of accidentally operates against itself. Like you're not intending to do that, but it's so complicated that you're going to lose most of your readers. And I think we have to think about that strategically in terms of how effective the task force's recommendations are going to be, right? So in any case, I think that those are two separate things. The bill does not go without a report from the task force. It's separate. Like they're two documents.
That is
Yeah.
what I was saying. I was saying
Okay.
the report that the drafting pig eventually creates, the idea is to give effect to what this pig or this task force eventually votes on. So I think here, this is the time for us to discuss what's unclear and what the task force needs to know from the reports here to make a vote on, are we accepting this recommendation or not? Then the drafting pig can go forward with those kinds of recommendations with the support of the pig's final report to create the final report of the task force as a whole. So my understanding is that we're not married to the report itself as like the language that would be going into a final report.
No, that's my understanding as well. I just, when the drafting pig meets, which I've already volunteered to do, and the first thing out of my mouth is going to be to ask somebody who was on this pig to redraft this thing into something a quarter of its length. So I'm just going to be blunt about that. I'm not going to do it. So.
Right, yeah, so what I'm clarifying is that, like, yes, we have a lot of information in this final report. And if there is some confusion, we should clarify it now so that the task force can vote on what choices it would like to make. And the drafting pig can take the choices the task force would like to make moving forward. I'm not sure who raised their hand first, Carol.
I was just gonna, I don't know how these things are typically presented and all that. I trust you all to guide me on that, but I was thinking, yeah, it could be very helpful to have some hypotheticals or a table or something that showed how an issue would be resolved under current law and then how it would be resolved under the amended UPA, because yeah, I'm sure Judge Hall can think of a lot of scenarios that we would have been really stymied under current law that this will help improve. And I think that would be very useful to people at the ledge too.
And I love the concept of a flow chart, actually.
Flow chart, I was thinking a graph or a table that shows how any one of these individuals would fall under the categories that are presented.
Comparing to current law, like what Carol just said, that's brilliant. I mean, if you had a little chart that said like the far left-hand column is a description of a couple, whatever their scenario is, like their relationship, the genetic relationships, then first column, what would happen under current law? And it's going to describe some burdensome, expensive process. And then what would happen if we enacted this bill? And it will ideally be describing something a lot simpler, a lot easier, right? And that would be the perfect way to do it because it's persuasive, right? To present it that way.
And would also reveal weaknesses in the process, right? It'd be a painful process drafting that, but I have a feeling
I didn't say it would be pleasant, just that it would be effective.
Force us to really understand how it works in contrast. But some of them won't be that complicated. Some of them will be can't make them a legal parent, and now can make them a legal parent. I mean, it's going to be some of the changes will be pretty dramatic and basic, but yeah, some will be more complicated.
Miyoko?
Oh, sorry. I think my hand was up from before. I forgot to put it down.
Is there anything that, we are here to discuss? Is there anything that needs to be clarified as far as what each of these categories does and how it's applied so that the task force can vote on the final report at the next meeting?
Actually, I have a question. It just occurred to me though. So for the art pig, do you consider this additional regulation of medical practices? I don't know who to ask.
Do we consider what? Like,
An
are you,
additional regulation of medical practice.
you mean the legal parentage pig recommendations?
No. I'm going back. Okay, I'm asking about the art.
I'm not sure that we can jump topics like that, but I would
Okay, sorry.
ask Sienna
I'll
about
wait.
that. Yeah.
Okay, I'll wait till we get there.
Sienna, I'm told there's a member of the public that has a hand raised. Courtney Jocelyn. UC Davis, I think a member of the commission. You see that?
I don't,
Is she not appearing on your end?
Brennan.
Should I tell her?
Raised,
There's 2 hands raised.
okay.
Should I let them in?
Yeah, just let one in at a time, please.
Yeah.
Hi, Courtney. I'd like to repeat kind of the limiting.
Oh, sure. Yeah, I wasn't, no, thank you for all your work. It's been really helpful. I actually had a question on the parentage pig, and I think this is maybe directed at Judge Hall. Thanks for all your work on this. So all of the confusing categories are included in the UPA. Happy to answer questions about them. I was a reporter, except for one category, which is new, which is this professed parent category. And I guess actually I still feel, having read the material, like I'm not quite sure what exactly the fact pattern is that would be covered by this new category. And I was wondering if Judge Hall or someone else might be able to describe the exact fact pattern that would be captured by this new process.
So the professed parents is somebody who, I'm trying to think of the best way to say this, is stepping forward and wanting to be named as a parent, so to speak. We're trying to tailor it so we're not stepping on the toes of the adoption statutes, obviously. But we still want to recognize it's the state's policy that we want children to have at least 2 parents. So it's that situation of somebody stepping in. I'm probably not saying this very well.
I guess, can I ask a follow-up question? Maybe
Sure.
if this is helpful. So I assume we're not talking about assisted reproduction, right?
No.
Because those would be captured by Articles 7 and 8. So pregnancy occurred here through sexual intercourse. And through this process, someone other than the genetic father would be declared to be the second parent. And I guess I'm just wondering, could that be anyone? Like they're just they just come into the life of the birth parent yesterday, but these 2 people decide that this person wants to be a parent. Like, are there any criteria?
So we were trying to prevent that situation. So there's a couple of things. We don't want them to be blood related, number one. They obviously not married to the birth parent, because if they were, they would all automatically be presumed. We also, we're requiring in our definition that they have to reside together as a family. And they have to hold themselves out as a family unit. And then the other thing that we added was this could not be done for any monetary compensation. So nobody can be receiving money in exchange for this process.
And I guess I'm curious why you felt like the holding out presumption and the de facto parent provision, I guess weren't enough for this kind of a fact pattern.
So de facto parent, the way I see the language, you can be a de facto parent, but you can't be on the birth certificate. A professed parent could be on the birth certificate and be a quote unquote legal parent. A de facto parent is not, the way I read it, is not a legal parent.
The way it works, so the way we drafted it, the way we intended it is that if the court finds the de facto parent to be a parent meets the requirements, they are a legal parent, they could actually get an amended birth certificate and they could be listed on the birth certificate.
Okay. I didn't realize that because, yeah, the way I saw it, the de facto is they're still not a legal parent. They can have custodial rights, but they're not a legal parent.
Rejoined.
So I'll take a look at that some more.
Gordon, do you have any clarifying, last couple of thoughts?
No, I'm happy to see it. Sorry.
Yeah, thank you.
Thank you,
Thank
Courtney.
you.
That was
Thank-
helpful.
Yeah.
I'm ready.
Brendan, have you ever second person? Hi, Jerry.
Hi,
Hi,
this is
Jen.
Tyler. Can you hear me?
Hi, Tyler. On legal parentage, correct?
Yeah, on legal parentage and considering the comments of all task force members on legal parentage and really all issues regarding the Uniform Parentage Act in general, I think it needs to be disclosed to the task force that one of the task force members owns an IVF clinic, which publicly states it is a partner of Donor Egg Bank USA, which is owned by Cooper Surgical. Thank you.
Brendan, you can take Tyler out of the, put it back in the meeting room. Thank you. All right. Does anybody else have anything to say or discuss about the final report of the legal parentage pig? We will have time to discuss before we put the report to a vote. But the time is now to, if there are any concerns or clarifying questions that need to be asked. And Jerry, did you want to say anything about the legal parentage report? I think you were not here when we made the introduction.
Yes, I do apologize. I I recently returned from an extended leave, and there have been a number of unfortunately rushes. But as far as the report, I think that the concerns are raised were reflected. Mark Nugent is the other member who is also Deputy Attorney General with the Child Support Enforcement Agency. Unfortunately, he is not able to attend today. And we had wanted to discuss this matter further. With regard to what was just recently said by the last person, who is he referring to as far as one of the members having an ownership interest?
Dr. Fratarelli.
He's referring to me, although it's not a ownership interest. I was one of the founding members, secondary founding members of the Donor Egg Bank USA. Those shares were subsequently sold before, like I guess 5 years ago now. It's part of Cooper Surgical. We still work with Donor Egg Bank USA as we do with other egg banks, but we get no financial benefits from them.
Thank you.
Jerry, did you have any more thoughts?
Yes, is it, do we have to take the vote today?
No, we are not voting today.
Okay, because I think I would like to have Mark here to also, provide some statements and before we vote.
Yeah, we will be voting at the next meeting. This is, yeah, discussion and presentation.
Thank you. And there was also one other, in reviewing the proposed draft bill, there were also a concern I had, and I'm going to have to raise it. I'll raise it with my PIG group. And I believe there should not be a problem, but it is something that I wanted to address before we took a vote.
So is this something we should bring up now, Jerry?
No,
This is the last meeting till we have the vote.
Yeah, we don't have any
Yeah,
more
Jerry,
pigs.
if you have something to discuss about the report, it should be raised now.
Yes, and the report did not address it, Judge Hall. So that is why I wanted to address it at a later time. And Judge Hall, perhaps if our PIG group can meet one last time, that would be good.
I'll be honest with you, odds are I won't be able to next week.
Well, the pigs are.
So we're not going to be able to modify the final report. This meeting
Right, this
was
is it.
to present the final reports because there's an entire 6-day kind of period before presenting a report and taking the vote. So anything that we also need to discuss that's maybe not in the report is going to have to be kind of figured out in a different way. Well, we may have to convene another PIG, but we can't amend the final reports.
Okay, thank you.
Deirdre?
Oh, I don't know if I might keeping track of numbers and stuff, but I know that Jeff had said he had to leave. Are we about to lose quorum in a few minutes or?
No, we'll be fine.
Okay. Well, I just wanted to reiterate that I thought the questions that the last public testifier asked to Judge Hall were very helpful, and I would love to know, Judge Hall, what you think of that, because that was actually the same thing that occurred to me, like, what about de facto parents, And I do think that there's so many categories of the parentage that one of the questions is going to be, do we really need that many in order to make this effective, right? So I would like to see if there is any chance of having a bit more conversation about that when you've had the chance to think about it.
And I'll take a look at the language again. I know the way we deal with de facto now is not considered to be a legal parent.
Gotcha. I didn't
And I
understand
guess that might
Okay.
be where my head is stuck at right now, is when I hear de facto, you're not a legal parent, but you do have custodial rights.
Gotcha. Okay. Well, even if you change that, for example, if the bill was to change what the phrase de facto parent means under Hawaii law, you'd have to make that crystal clear, because otherwise all of your colleagues are going to think the same thing based on what it's always meant before. So I think it's a valid point either way, regardless of what direction you go, on whether you think that the language in the existing UPA is sufficient to address like those kind of fact patterns. But I would really value your insight on that, the utility of all these different categories.
And just to confirm, I will be able to discuss that more at the next meeting.
Yeah, so we can still do deliberation and clarification. It's just that this is the time for presentation and the time we have to discuss, but we will have time.
Yes, I'll make sure to do that then. Thank you.
So yeah, so the time now would be to any clarifying questions, so that if anything needs to be kind of teased out before we vote, today would be the time to raise any of those. confusions, concerns?
If we can, excuse me, Sienna?
Yeah.
My question had to do with page 20 of the legal parentage permitted interaction groups proposed draft bill. And Judge Hall and those members of our group, Sienna, it's item K. It was not raised before, but we are working. That is Child Support Enforcement Agency and the Department of Health. We are working on converting to, and Lauren Kim is here, an electronic version of the VEP form. And I noticed that it will be signed by, it can be signed by the individual who gave birth to the child and the individual seeking to establish a parent-child relationship, and signed by a witness. I was concerned that the electronic version that had been, the language that had appeared included everyone who will be signing that form, but I think signed by a witness. So the question is whether or not that also includes a notary. And I think it's broad enough to include a notary, but I would like to have the group's input. And again,
You want input whether a notary should be required on a VEP?
No, there are circumstances when the notary is required on a VEP, and that is the Department of Health form. They refer to a witness, but the question is the witness, is that broad enough to include a notary?
I think a notary is more restrictive than a witness. So because, I mean, if a notary, it's somebody, you're providing their ID, your ID to, they're confirming you are the person, and that's what they're basically signing, yes, I'm confirming this is the person. Versus a witness just saying, yeah, I saw this person sign.
Notary is kind of like a witness on steroids.
Yeah.
I would definitely say
Maddie?
a notary counts as a witness. A witness obviously does not count as a notary.
Yeah.
But it can be
Right,
hard
although
to get.
I'm not sure
it can
whether
be-
notaries are willing to serve as a separate, if a witness is required, they might say no, I'm not a witness, I'm just a notary, right?
As a practical matter, it can be hard to get notaries into hospitals. I have to bring them with me when I do my my
Yeah,
agreements.
that was gonna be my concern is are we gonna require the hospitals to have notaries on staff?
They refuse so far to ever provide a notary. We have to bring mobile notaries.
Yeah, I wouldn't
As you-
want to do that. That seems, burdensome in an unpragmatic way, right?
As you can imagine, during COVID, it was a disaster needing a notary in a hospital.
I agree. And the hospital form does not include a notary the witness would be the witness,
Yeah.
hospital staff, and that is sufficient. It's in a situation where Department of Health subsequently is presented with a birthing mother who wants to have the parentage established utilizing the VEP form. And the other parent is not before the Department of Health, but let's say has moved to another island, another state, and therefore we have a notary section for that individual to be identified as the person who has attested that they are the person who is signing the document.
So if notary is already required, then what's the issue?
Well, the language that appears is, does indicate, does recognize that the document must be signed by a witness, but there are circumstances where a notary must sign. So I'm wondering if maybe we should include the phrase by witness or notary to include the situation where we do have a notary signing. And I know the Department of Health wants to move towards an electronic notary. But I think that word notary should be included.
But I don't understand, Jerry, at the bottom of page 20 of your guys' section of the bill, it says
Yes.
shall consist of a single form signed under oath. So how are they going to do that without a notary?
That is,
Are you imagining that they're just signing something under penalty of perjury, like a declaration? Or
Yes.
you're imagining, okay,
Under
you're just
penalty of
imagining a
perjury.
declaration. Okay,
No.
it seems to me that as currently written, it requires a witness and signed under oath, which is just like a declaration saying you're signing under penalty of perjury does not presently require a notary. But if you say that there are situations, are there other statutes that require that these things in some circumstances be signed with a notary?
Jeff, please remind us.
No, we're fine.
Are we good?
Like another law that requires something to be signed with a notary? Oh,
We have 9, we still have 9.
okay, sorry, yeah, my math isn't too good right now, but
Yeah, she's right.
yeah,
Yeah.
and that's a good, Deirdre, that's a good question.
because a single form signed under oath is just like, you know, when you sign your tax returns, right? There's no notary, but you're signing under penalty of perjury, right? And any other really serious document. And so we're already requiring them to do that. So if there's some separate legal requirement that requires that some of these forms be notarized, then we can say, or a notary if otherwise required by law. But if a notary is not presently required, right?
No.
Yeah, it just says sign under oath.
yes,
So I think that your concern is actually already addressed by the way the statute is written.
okay,
Yeah, so it's like the individual who gave birth, the individual seeking to establish parentage, and a witness, and then the person who's establishing parentage is signing. All of them are signing under oath, and it's one form.
and that has not been a problem at the medical centers or with the midwives, simply because we have through the years had training, and the hospital staff, the midwives understand their obligations. It's situation becomes more complex when you deal with a situation where the party signing is not being signed in front of either it does not sign before the Department of Health staff, who are authorized pursuant to statute to act similar to a notary.
I mean, I'll be honest, from personal experience, the hospital doesn't have anybody standing there while you're signing the paperwork either.
That's right.
So, I mean, that's just the current situation.
That's cool.
Well, we are, but in training, they're told they should be present, and if they're not, well.
It also says they're supposed to give you access to a video, and they don't do that either.
We do have a recording.
Yeah, but the hospital doesn't offer it. They don't tell you about it. They don't do nothing like that.
The pamphlet that they give has that information. And so it's something that the parents have to read. Anyway, this is something that I raised. I was concerned in terms of signing, And yes, it's signed under oath, so yes, there's a witness. But there are other situations when the document is not signed in front of a witness. And in that case, especially when the document is taken out of a situation where it's an untrained person, then we resort to having a notary present to attest that that person who appears is the person who has completed the documents and who is signing the document.
I think Lauren might have had to leave, so we better.
Okay.
All right. Any last thoughts? Okay, so we'll move on again. We can discuss all of the final reports again before we submit our motions to vote. So please be thinking about what parts, or pull the entire report, or that there are parts that you would like to vote to incorporate or to accept as a task force in preparation for next meeting. So I'm going to move on to our action items. I'm going to actually postpone action item C1 till next meeting. I just want to do C2, which is to dissolve the legal parentage, birth heritage, and assisted reproduction and surrogacy pigs and recreate them with the same membership, scope of investigation, and scope of authority, so that they may discuss any of the questions that were raised now in preparation to further clarify anything at the next meeting, in which we will vote on the final reports. Any comments about that?
I had discussed with Lauren before she went out on leave that, if we reestablish the pigs, would they be available to the drafting pig for questions? Is this gonna make that into a yes?
No, so the pigs will be available. This is so that the pigs can discuss before the next meeting.
Right.
Things that were raised now. I can re-up the pigs to going forward. However, we aren't going to be able to let a drafting pig member discuss with another pig outside of a task force meeting.
Well, that's not possible because everybody's on at least one pig. So there is nobody on the drafting pig who isn't on another pig.
Yeah, right, but those people would be on the drafting pig, so you're allowed to discuss with the people who are on the drafting pig. But with my understanding that you were asking to be able to discuss with the entire pig.
No, I don't know how this can be done, but what I would like to have as a resource for the drafting pig is that, because I volunteered to work on that group, that the drafting pig have the option of contacting these like substantive area pigs for clarification, because the purpose of the drafting pig is to make sure that the proposed bill implements the recommendations adopted by the task force. And I was hoping there would be a way to do that. Perhaps there is not, but that's what my question is.
As we've mentioned, there's probably going to be at least one person from each pig on the drafting pig. So to the extent that that person has personal knowledge and can clarify what they understand of the report, that's the extent of your access to the pig.
Okay, well, I don't think that's the same thing that Lauren told me before, but if that's your decision, then fine.
Okay, that is all we have on the agenda. If there's nothing else, I'm going to adjourn this meeting at 2:38. Thank you all for making the time to be here today. I will see you next Friday.
Thank you, everybody. Take care. Have a good weekend.